I guess we'll get started. Welcome. Thank you all for coming to Arnold & Porter this morning. My name is Gil Sirota, and I'm a partner in the San Francisco office. I do litigation, and I came via the merger with Howard Rice as of January 1st. Our bios are in the little booklet, so I'm not going to go into it in great detail. This is Marcus Asner. He's a partner in our white-collar crime group. He was a former assistant U.S. attorney in the Southern District of New York, and he works in our New York office. Yusuf Kasim is from Charles Schwab and Company, one of our dearest and most enduring client relationships, and he is the head of their legal intellectual property group and does a lot of work in the area of privacy and data breach and so on. And Ken Chernoff is a partner in our D.C. office, formerly with the Justice Department in Washington. He is the head of our business litigation group worldwide. And Marcus and Ken are the founders of our data breach response team. And they put together a group of folks who are trained and ready, willing, and able and employed doing exactly what we're going to be talking about today, which is helping clients with internal investigations and litigation and regulatory matters arising out of data breach situations. So I thought, rather than mentioning what Eric Holder said, which is important, yesterday there was, let me say one other thing for California law purposes. This is being recorded, okay? Also, you should feel free to interrupt us with questions and have a dialogue as we go along. We want to have this informal and meet your needs in terms of responding to what your concerns are. But we are taping this. It'll be posted on our website, and a couple of clients who couldn't be here today wanted to listen to the presentation. Yesterday, there was a press release by Joe Lieberman, the senator from Connecticut, about the need for further cybersecurity legislation. And I found a couple things interesting. The head of the National Securities Agency and the commander of the U.S. Cyber Command said that the theft of industrial information and intellectual property is the greatest transfer of wealth in history. Companies lose $250 billion per year through intellectual property theft, and another $114 billion due to cybercrime, a number that rises to $338 billion when the costs of downtime due to crime are taken into account. And I think you've probably seen a couple of press reports about a survey that was done of mid-sized companies where fully 50% of the companies in the survey reported that they had been victimized during the last 12 months by some form of data theft or hacking. So this is a real serious problem that's very likely to hit everybody in this room, law firms included. I thought Marcus could take us through just really briefly from his perspective as both a prosecutor and as a civil litigator, the types of data breaches that we are seeing and where they're arising.
So welcome everybody to Arnold & Porter. Our hope is that this is going to be a small, intimate crowd where people can add things and discuss. In my past life, when I was in New York as a federal prosecutor, I was chief of the cybercrime group and handling a lot of the data breaches from the government side. And now that I've been at Arnold & Porter for the last 3 years, I've been handling it from the civil side, so I have a little bit of a different perspective. It's a little bit odd for me to be in Silicon Valley and tell you about cyber threats, because obviously this is the epicenter of a lot of this stuff. But let me go through it briefly, at least from my perspective as an attorney. Data breaches are the things that are very much in the news these days. To me, the astonishing thing is just the trend. In 2004, when I was a prosecutor, I issued a press release because I had just taken down the biggest identity theft in U.S. history, and it was just astonishing. It was the front page of the New York Post, and that was 30,000 credit reports, and that was the biggest ever. And now, many years later, I'm dealing routinely with millions of identities stolen, and it's just gone up. And so the trend has gotten to be that these things are bigger and bigger. And a lot of that is just because of the use of more and more data on computer systems. Now, not all data breaches are the same. The Cummings data breach, the one with 30,000, was 30,000 credit reports. So there was a lot of information. And one of the things that we're seeing is there may be larger data breaches in the sense of volume, but the information may not as useful for some of the bad guys. But there's other threats out there for you and your companies. Obviously, there's hacking. You're all very familiar with it. Anywhere from some 17-year-old kid who's hacking into some the DoD website because he thinks it's fun, to actually people going out there and trying to get data for the purposes of doing bad things, to destroying your data and stealing your trade secrets. Botnets are a big thing in the cyber world, where a huge proportion of the PCs in America are actually controlled by other PCs, and they serve as slaves. They're called bots for robot, and they're nets. And so the bad guys will use these, and one of the things they'll use them for is a dedicated denial of service attack. The easiest example of that is they'll send 1 million emails to the same email server and to try and crash your system. And it turns out that these various cyber attacks are, people think they're immune from them, but I thought it was very telling. In December of this year, I got a call because one of our clients was somehow wrapped up in the mega upload case. And so I was watching that throughout the day, and mega upload, some people were arrested by the Department of Justice. And then later that day, the Department of Justice website crashed because the Anonymous did a denial of service attack on them. One area we're seeing a lot of these days is corporate espionage. It's a huge part of everything. And then, of course, also that's foreign espionage. That's a big focus of the Department of Justice these days, but also of our clients.
All right, and let's just turn to how this impacts companies. And Yusuf and Ken, you might want to have some comments on this. Obviously, bad publicity is at the top of the list, and damage to companies' relationships. But
sure. Yes, I think Gil started the presentation talking about the impact of how much money is lost in the cyber threat space. We've been successful in as much as the folks hacking into our systems are becoming more sophisticated. So are we, managing the hacking, watching the systems, watching trends. For example, we'll continuously monitor your IP address when you log into your accounts, so we can see consistency. If we note that you're more than 500 miles away from home, we'll send you a robotic ping to add an additional password, or ask you for different passwords, so that we certainly still you checking into your account, etc. If you're one of the customers that likes to use a cyber cafe all the time to access your accounts, we'll send you a token, which is a further authentication mechanism. So we try to keep up with the sophistication of the hackers, and I think there's a lot of publicity about how great the hacking folks are, but there's lack of publicity showing how much money we're not losing right now. So we are keeping up with them, and there is this little balance that's in play. But unfortunately, it's one failure that causes all the problems for us. If there's a massive failure, we face publicity issues, we face damage to business reputation. We have a statement out on our website guaranteeing you that we'll stand behind our security and your money. That's all expensive for us if there's problems. Then you have the regulatory agencies managing us. Since GLB, Graham-Leach Bliley, we need to be careful about how the NPI is protected. If we contract with third parties, how we protect your NPI, the requirements we put in place in agreements, the indemnifications we seek from various vendors. And then there's always a threat of both criminal and civil litigation against companies that fail to protect the data. But again, it's the reputational harm that we're worried about. And we have an elaborate process in place. We'll get into the decks later when there is a breach, what we go through, how we protect it, how fast we respond to the individuals, what measures we make available, and how we protect your data. From a financial services company, a very busy brokerage company, we've been lucky. We haven't had a lot of exposure to breaches. simply because I think we have a very good technical staff, we have a very good ISS group, and good forensic folks working our back-end systems to ensure that your data is kept protected and private.
Let me ask you a couple of questions. There's been a couple of major items over the years where online trading systems, not just Schwab's, but others, have suddenly gone down and customers couldn't transact. Have in the industry, has that ever been traced to kind of cyber crime as opposed to just a technological issue?
It's mainly technology or servers going down, or you had the problem in New York where the power circuits went down, the exchanges couldn't work. We had issues where the systems did slow down because of volumes. A lot of trading volume comes in. You have massive servers in place. Lots of MIPS are being used, but at some point you need to switch machines on to take the volume, and you try to load balance. Times when we've gone down is when the load balancing didn't work out, the systems didn't communicate well, and then suddenly things slow down and trading is halted. Or if there's over trading in a stock, we'll just halt it from the exchange perspective because we've been told to start slowing it down. But no cyber trade, to my knowledge, cyber hacking has brought any systems down from that perspective. You had the big problem with ChoicePoint and their breach around sensitive data, but that was more their systems and some stuff on their end that caused it. That was all the publicity on that topic.
Thanks, Ken.
I'm just going to say I'm glad to be here. Thanks for showing up. And it's a very fascinating topic. I get involved in the civil litigation, so I get involved hopefully at the front end when there's been a data breach or a hacking or something that's presents some exposure for a company. More often than not, when I get involved is when the threat of litigation has emerged, or an actual lawsuit or set of lawsuits has been filed. And I'm really glad that Yusuf is on our panel today, because I'm amazed that he and Schwab have been able to avoid any significant litigation. It's actually a remarkable feat in this day and age, in this area of the law, because as Gil was kind of recounting how data breach privacy issues are becoming more and more commonplace and sort of common in the public press and the news. Everyone's kind of talking about concerns about privacy. People are much more attuned and concerned about their personal data being compromised. And as a result, with the advent of some new laws that you've been dealing with that we'll talk about, there has grown a new plaintiff's bar, which is much like the securities plaintiff's class action bar that emerged in principally in the 80s, is growing similarly in the data breach security area. And these folks, prowl the public press for disclosures regarding data breaches and similar events. And more often than, frequently now, they are filing lawsuits, where you file first and ask questions later. And even those lawsuits, whether they are meritless or not, pose a lot of reputational risk, like you were describing, Yusuf, and potential exposure to a company. So
we're also seeing the state AGs coming in more and more and filing suit, and also the FTC, of course, is a big regulator in this area.
Yeah, the FTC fined Google yesterday, 22.5 million, I think, around the way they circumvented the privacy protections in Safari. There seems to be a battle between Google and Apple around Safari and how the privacy controls work in the technology. But the FTC also has a requirement on companies like Google and Facebook to annually provide an audit plan about how they intend to protect your private information, as opposed to Twitter, which will have to file a plan as to how it intends to protect the information from being hacked. So it's a slight difference as to Google will come in and say, this is what we're going to do to protect how we're going to use your information. So on the use factor itself, I think the companies like Google, Facebook are going to see added pressure from Europe, which has stricter controls that may then set the standard for us to follow here once they can deal with the European Union and their requirements. But from our perspective, we make certain that we're monitoring a lot of the trends on a daily basis on how the accounts are being used, and that We have a whole team dedicated to that piece, and they will then feed that information to the data folks to tell them we're seeing the following trends on these accounts, so that we are ahead of the game. Now, it's not foolproof. There's people hacking from all over the world. But we feel confident that if something is compromised in the U.S., between U.S. banks, we have a 3-day period to remedy the situation, so you will not see the problem. We'll fix it. Your money will be redeposited into your account, and you should be fine. It is when that money goes to a Chinese bank or a bank in some other part of the world, then there's a problem. There's an exposure, and we're just going to eat the loss and give you your money based on a guarantee. But if it's U.S. bank to U.S. bank, systems are pretty robust. You have the 3-day rule to fix things, and so hence you don't see the publicity around some of the problems. The key for Schwab is as soon as we have a breach, there's a process that kicks in. It's a very robust process. Each state has their own requirements of disclosure. We'll go with the California rule, which is the most strict rule. We'll do an analysis as to what is being breached. Is it just the individual name? Then it's not an NPI issue. It doesn't trigger all of the concerns as much as name, account, and one other factor like a social security, digital signature. If any of that's compromised, then you have an NPI breach. Then the process kicks in. There's a team dedicated. We don't want to be transparent at that point, but there's a lot of communications up and down that need to be consistent. Legal gets involved to preserve the forensics that emerges, and within 48 hours, we'll have a solution for the customer. The last thing you want is the New York Times picking up this piece or the Wall Street Journal. We need to comply with AG requirements, so then we'll notify the various AGs. New Hampshire is one of the tough ones. It's an online notification. As soon as you do it, all the privacy groups will pick it up and they'll publicize it. So
I think we're getting a little bit ahead of ourselves. We'll get to that very shortly. Let me mention, just related to the privacy issue, one of the other areas of litigation that we're seeing a lot of is private litigation over telephone recording, incoming and outgoing. If your companies record phone calls from customers to customer service lines and so on, you have to make sure that you have a pre-notification on there, or you're subject to, basically, it's a $5,000 per recorded call minimum damages. So it's a big thing. Plaintiffs' lawyers are bringing these kind of cases, and it's always a good idea to remind your companies and your clients to make sure they have pre-notification on recorded calls. All right, so what we do is we work on all 3 of these items: planning, responding, and anticipating litigation. And we're going to cover the whole range of these through these 6 topics today as our roadmap. And we're going to use a hypothetical as a basis for discussion, which was drawn from one of the cases that Marcus worked on. And you can sort of explain the facts. We're going to hypothesize that Yusuf comes into work in the morning. By the way, this has nothing to do with Charles Schwab. Comes into work in the morning and he's confronted with the following. So
okay,
yeah.
So let me explain. This is an actual case that happened while I was at Arnold & Porter. It was a financial institution client. It was a UK financial institution client. And as we're going through the deck and the hypothetical, we can change some of it along the way so you can start thinking through things. But what actually happened was they had a data breach about a year earlier, but just in the UK, and they thought they had solved it. They had changed some passwords. But then a third party called them up, and he claimed that an insider sometime earlier had committed a data breach, which we knew about, but we thought we had solved the problem, that the data was actually being offered for sale on a Russian carding site. And I don't know whether you guys know what these carding sites are. They're sites where the bad guys actually have an exchange, where they'll exchange data, and they'll also exchange expertise. Like one guy may be really good at cracking passwords, and another guy may have a lot of credit card numbers, but he's not really good about turning them into money. And so they'll exchange information. They have really funny names like mazafaka.com, which or .org or something like that. It's really kind of fun. But at any rate, our data was being offered for sale on a Russian carding site. And the allegations were that account numbers and passwords had been stolen. And this individual was threatening to go public. And so that was what we were faced with. It was, for the company, effectively a bet the company matter.
All right, so we're going to hypothesize that Yusuf has come into work in the morning and one of his colleagues has informed him that this third-party call came in, and he's gotten a hold of Ken and Marcus because they're part of the data breach response team, so he knows that they have expertise. And these are going to be some of the concerns and some of the issues that we typically talk to clients about. And maybe, Yusuf, you want to work us through what a conference call might look like between the three of you.
Yeah, so what will happen is we'll get notice from our information security folks of the potential breach, or in this instance, someone's told us that an insider has shared some sensitive information. I'll immediately go into this, try to lock down the systems for evidentiary purposes, understand whether information is coming from call markers, and tell him we have this situation, and he'll tell me, let's verify if the allegations are real. We'll start with the concept of, is this a real allegation or not? And from that point of view, the data incident response plan kicks in. Various groups within Schwab will be informed to get together, start the meeting process, and we'll get the call going with Marcus and have him lead what he needs to do at that point.
Yeah. So I mean, what we're looking at, you've got an allegation, and so the first thing is, who cares? I mean, is it true? Is this somebody that is, first off, is our data actually out there? What is this person's motivation? Is he trying to extort us? It changes the color of things. Because if he's just being a good Samaritan, then maybe you can work with him. But if he's trying to extort us, if he wants something, then it goes more into the realm of, we've got a real problem child on our hand. And questions immediately arise of how do you investigate it, and what sort of exposure you might have, et cetera. So these are sort of the initial concerns, and then we'll go on and talk a little bit about how we think through some of these problems.
And the first thing that I would say, having heard Yusuf say what he just said, is I'm really glad to hear that you already have an incident response plan in place in advance. Frequently, especially with smaller companies, startup companies, there are many things going on simultaneously, and the concept of having in advance put into place an incident response plan may not be the top of the to-do list. However, when there is an issue or a potential issue, like a threat that somebody has stolen some data, or a breach, or a hack, or whatever it is, there's a natural tendency to have the house is on fire kind of reaction, and all hands on deck, and oh my God, what is going on? And the chaos can be very problematic, because the record that's created during the moments of chaos can be very damning to the company down the road.
I'm sorry to interrupt the flow, but you hit upon exactly what I'm always afraid of, is when we get to sensitive issues, how do you be productive and efficient in getting the right people in the room and communicating the ideas, especially if some of the people you need to speak to are 3,000 miles away and on their BlackBerry or their iPhone.
Right.
Is it okay to put, attorney-client privilege? I mean, how do you isolate that correspondence so it doesn't come back and bite you?
It's a great question. I mean, I think there's two answers to it. One is, I think from the get-go, and we'll talk about this a little bit later, you want to have a plan in place where you already know what the phone numbers are. I mean, you have fire drills. Everybody, a couple times a year, everybody's supposed to walk outside or walk to the stairwell or whatever. Same sort of thing. Who do you call? Who's in the inner group? Who's the fire warden, effectively? And that's the sort of thing you need to do. And then another thing you need to do is, the big issue is, who handles this? Do you handle this by counsel, or does your IT folks handle it, or do your security folks handle it? You've got to have that thought through beforehand. The answer, I think, in almost all of the cases, if you have a real data breach, is you want to have counsel involved from the beginning, because you cloak all these things in privilege. So all the mistakes along the way, as you're sort of brainstorming, end up being, say, oh, this is work product, or this is attorney-client privilege, because you're thinking through problems and you protect it. Otherwise, you're dealing with, Ken has to deal with it 2 years later in a civil suit where people are, making mistakes, sending emails that are, going off half-cocked, and these end up being source of depositions.
The message we deliver is, do not panic. You have a plan. It's a robust plan. It's been tested. There's numbers, there's folks you contact. If you can't get the first individual, there's always an alternative. There's cell phones you can reach them on. You have counsel immediately involved so that you can start the privilege and preserve the evidence. And then you want to also have a single point of communication, both up and down. So we involve our media folks. We'll shield some of the executives at the early stage because we don't want them to be put in a spot for a quick question or so in case they had some function. And then work with counsel internally and externally to document the sequence and process and preservation of all the documentation you get together, and then start going through the process of verifying the allegation. Is it an extortion or not? What are the next steps? Do we have to notify various states? And it starts flowing from that process because you have a plan to follow. If you don't have a plan, it's going to be chaos.
I think one of the difficult questions that maybe you and Ken could talk about is, when would you have to escalate this to, say, board level or high-level management so that they are not seen as having been uninformed and not doing their duties of oversight? And when do you have to make a public disclosure to protect your stock price and SEC to the SEC?
Well, I'm happy to start off. That's a common question is the one that Gil just asked, which is, at what point do you need to get the most senior management or the board of directors, involved and informed,
And the auditors.
and the auditors, the audit committee, and there's no actual answer to that question. It's really kind of a sliding scale like you'd find in any kind of business situation. There are all sorts of business events that happen that don't necessarily need to rise to that level. However, there is a risk. Keep in mind there's a risk down the road, and we'll talk about this later, of not only the civil litigation, class actions and such brought by consumers who have been allegedly injured by the incident, but there can be derivative claims brought against the board by shareholders who claim that the board of directors or members of the board of directors of the senior management of the company breached their fiduciary duty by not taking steps to prevent or mitigate a business-threatening incident. So just to answer your question by backing out of it a little bit more, the first thing you want to do is be comfortable that there is a process in place to identify and deal with incidents if they arise, and that the board is sufficiently aware of and has blessed that process. That is a very good housekeeping thing to do, so that later on down the road, if something bad happens, and bad things do happen, people lose briefcases with discs on them, and the board of directors is not going to be able to prevent that from happening. But if they in advance have been presented and blessed a process for dealing with those and mitigating risk, they're going to be in a much better position to ward off any kind of future claims of in derivative lawsuits. In terms of bringing them to their attention in the securities laws, there is some SEC guidance on this in terms of when you need to make disclosures to the public. But the rule of thumb that I always operate on is anything that's going to have a chance of having a material impact on the business of the company is something that needs to be brought to the board's attention right away.
And if there is a need for a disclosure, is this handled in like an 8K where you would file that with the SEC, or is a press release, or what?
An 8K is typically if it's there is now guidance, and I don't know if you've seen this. If not,
by the way, it's in our material. You can take a look later, but there is an advisory about the SEC guidance.
Yeah, the SEC has issued some non-binding, at this point, non-binding guidance. But when the SEC issues non-binding guidance, it's a very good idea to pay attention to that non-binding guidance. And it's a little bit vague. It's worth taking a look at, and we can talk about it in more detail if you'd like. But it does set out some standards that would sort of let you know when you should make a public disclosure via an 8K regarding an incident. And it's really the same kind of standards with regard to any other incident that would result in an 8K.
And we always try to tell our clients, when in doubt, disclose. If you feel like it could be a material impact, get it out in the public domain as soon as possible, because that's the best way to avoid shareholder ultimate shareholder litigation or an SEC investigation.
And here it's so different, with one exception, I would say, which is that it's very important to think very carefully about when is the right time to make that disclosure. Because remember, the first couple of days of a following incident, as you just said, you may have, the house may be on fire and people may think that the whole company is going to come to a screeching halt. It may not be true. So you really want to make sure you're not disclosing until you have a good grasp of what happened and what the potential exposure is.
And a lot of it depends on the particular data, and whether, and will that data actually be useful? And we'll go into that in a minute. She was asking a question.
Oh, I'm sorry. Sure, go ahead.
Okay, I wanted to follow up on this gentleman's question. So it's easier to get control in the very beginning when an attorney gets involved, saying, I'm involved, all emails protected under privilege. But once the investigation starts going and you get your IT or you get other people talking, there's a lot of chatter going on to try to figure out what's going on. How do you protect that? Because I don't think just CCing an attorney doesn't really work.
No.
So how do you protect?
Go ahead, Ken.
No, you go.
Well, all I was going to say is, look, when you're doing one of these investigations, you try and control it, and you try and make sure that things are done at the direction of the attorney, and then you keep the group of people small, so it's a smaller group that's at the direction of the attorney. You try. It doesn't always succeed, and you fight these civil cases. You fight these privilege issues every step of the way. But
so I'm not a privilege expert, but if an attorney gives the direction to a group of team and you're able to keep the team concise and small, then if those team members are acting at your direction and just communicating with themselves, that's protected.
Well, that's more under the work product.
That would be
That's
work
under the work product doctrine because it's in anticipation of litigation and it's being done at the direction of counsel. So the team itself communicating among each other as well as to and from counsel would be protected in civil litigation.
But you hit an important issue also, which is that the boundaries of that privilege get very fuzzy. And so, if an attorney is directing the head of IT to do the following 5 things, those communications are probably going to get the most protection. But then when the head of IT gives direction to her subordinates to do something, and they reach out to another person in the business, the farther out you get, the harder it is to protect that privilege. So you do want to keep the team as contained as possible, and you want to have people taking some nice prophylactic measures, like referencing in their emails, at the direction of counsel, we've been asked to do this, will you do that?
In your kickoff meetings, counsel will explain the concept of the privilege, the work product doctrine, and we'll tell them to make certain we copy them, the main emails initially. Again, it's a small group, it's a contained process, and it's manageable. It becomes unmanageable when everyone's talking about it and everyone's panicking. It's in your systems. We have good technology. We can go isolate the systems. We have good ISS folks and good investigative folks on board. So the group is small.
The one small, just a little tip that I would recommend is a lot of companies who approach this will create a shared site, and they'll just, from day one, and so they'll just tell people, whatever you do, have all your emails and all your documents dumped into the shared site right off the bat. Don't worry, don't parse whether you think it's privileged or not. Just put it all in there, and then you've at least got a contained set of materials too.
Well, like anything else that I've been involved in, what you do in the beginning is really critical, and how you investigate and what you do. And one of the issues we're going to cover is when should you, might you, and when do you have to get law enforcement involved, and how do you effectively investigate without creating a record that's a roadmap for either civil litigants or a government investigator. So, Marcus, why don't you start covering those issues?
Sure, and we've touched on some of these things already, and we'll try not to go over it again. But one of the first questions I get when there's a breach is, should we call the police? Should we call the FBI? And I'm a little conflicted because 3 years ago when I was in the government, I would go around to these forums and say, well, the first thing you should do is call me. And now that I'm more mature, I realize it's a little bit more nuanced than that. There are some real downsides to calling the government. government. We'll go through some of those in a moment, but the most immediate one for the present purposes is that it's not privileged. And if you go off half-cocked, and you don't know the answer to things, it may be that the information you're providing to the government is wrong, and you can't control it at that point, and you have all these other problems about what you say to the government. Usually, it depends. There will be times when there is health and safety that is going to be a real problem, and you need to call the FBI right away. But in almost all of the situations I've dealt with, you have a period of time to actually take stock of everything.
Marcus, sometimes people ask me, and I just direct them to you.
Yeah.
But, is my company at risk as a target of a criminal investigation? So if I reach out to the FBI because I'm thinking that it's the appropriate thing to do for the protection of the public at large or to capture the person, but am I exposing my own company to?
You could, and that's the odd thing. I mean, in most of the data breach cases, the government views the company as the victim. All right, but there are situations. American criminal law is extremely broad when it comes to corporations, and a corporation can be held criminally liable if any employee commits a crime, and that crime is in part for the purposes of aiding the corporation. So in most of the data breach cases, it's not a problem. But there are sort of perverse examples where it could be a problem. Where, for example, there is an employee or a group of employees that aren't favored by management, and so they reveal private information out into the world, for mixed motives, but in part because they don't like the person anymore. That could be criminally liable, lead to criminal liability from a corporation's point of view. Other areas is, a lot of the data breach statutes, a lot of the data notification statutes, if you don't follow them, there can be criminal liability attached to those. And then, if you get out of the data breach context, so for example, in the corporate espionage, if you hire 5 employees from your competitor, bringing them over, and in part because in your minds you're thinking, well, they've got some really cool trade secrets and I'd like to get those, that's a crime. And you as a corporation may well have committed a crime at that point. So there is criminal liability here.
So if let's say you get to the point where your investigation suggests that a felony was committed, let's say you have information that a company employee was bribed to provide data. Is it mandatory at that point to report to the authority?
It's not, at least not across the board. It really depends on the particular industry, but there is no across the board self-disclosure requirements in the United States. Now, some industries have it, and then publicly traded companies oftentimes have various obligations, and then there's all these issues about whistleblowers and should you report or should you self-disclose early and try and avoid criminal exposure. But there at least in sort of core criminal jurisprudence, there's no affirmative obligation to self-report, but it may be in your interest. And then some of these other things like the SEC disclosure requirements and the victim notification requirements effectively make you self-disclose. So you might as well, at a certain point, go into the authorities. But important safety tip is don't necessarily go in right away until you know the facts. And just touching on the investigation, one of the issues that we deal with a lot is in-house counsel oftentimes can do this themselves. There are some advantages, though, particularly with smaller companies, of having outside counsel do it, or larger companies. One is that the smaller companies may not have the expertise to do these investigations themselves, but it may also be that that by bringing in outside counsel, you inoculate yourself a little bit better because you have independence. It also helps you a little bit better with the privilege because you may be the general counsel, but you may also be the COO of the company. So you're wearing 2 hats, and somebody years later says, well, you were really acting as the COO there, not as the general counsel, in which case they're saying, well, let's get through that privilege. The whole bit about how you end up engaging folks, in my experience, in my view, I think that you should, all the vendors that you end up going out to hire, the forensic people who help you work through some of this stuff, they should be engaged by counsel because that helps you get the privilege.
In terms of, let's talk to Yusuf for a second. You've got a legal department you've got an IT department, you've got a corporate security department, you have outside counsel, and presumably you have some vendors who are engaged in this area. If you're the guy who got the call, how do you allocate responsibility or functions among all those groups?
So we have, that's defined in the plan, and the plan calls for legal, ISS, and the risk groups to get together initially, and at that point, legal will decide whether we're just going to keep it in-house or we're going to engage outside counsel, depending on the severity of the issue or even on the timing. Sometimes if the breaches occurred in a state we're not admitted to practice in, it's easier to get outside counsel to assist us with some of the local requirements. If it's a severe breach, you go to outside counsel. It also helps the business understand this is very serious, take it serious, let's start moving on the plan. It also helps us convince our regulatory agencies that we've taken this stuff very seriously, because that's part of our battle, is to convince the OCC and other regulatory agencies that we did not do what they want us to do in this situation. And it's a perception issue, and you beat them at that, you're fine. In the end, with the individuals involved, and it's a money game. We'll make money available to make them happy so they can do the reporting on the credit reports or certain different agencies. But again, it's the urgency and showing the regulatory agencies that you've got a plan, you're following it, and you're not just sitting and doing nothing.
And let me add one thing, because I think this is an important point, is in this particular hypothetical, you've not heard about this hypothetical. You've not heard about this client because we never disclosed. We never disclosed to the FBI. We never disclosed to anybody about this. We changed a bunch of everybody's passwords. We made everybody change their passwords. But working through the analysis and working with outside counsel, the company, and there were 5 million records stolen, the company elected, and we think it was legal, to decide not to self-disclose. And for the company, that was a big win, not to self-disclose.
And I would just say, from a corporate governance standpoint, those of you who work for public companies, there's been a tremendous emphasis on risk management, having a subcommittee of the board of directors that is the risk management, and to at least escalate something like this to the risk management committee, because from a corporate governance standpoint, that protects your board and it protects the company from an allegation that you covered it up, that you just swept it under the rug and you didn't do anything. And most public companies are now having very deep and rich risk management processes, and this is exactly where you would want this thing to end up, is at a risk management committee that both looks at the severity of it, looks at fixing it, looks at disclosing it, addresses all of those matters from a corporate governance point.
And getting back to your point earlier is, you don't start looking for vendors the day after the breach. We have our data breach response team. We've interviewed and have 3 vendors ready to go, and we'll let the client choose the vendor. But these are the ones who are used to us, used to our procedures, and that's the same thing you should do. You should have your vendors ready to go as part of your fire drill. Who are you going to call? Yeah. Who are the vendors? Who is the law firm? Who is the lawyer involved?
Question?
Yeah, this example feels fairly U.S.-centric. What if some of the data that was in here included, European data, German information, etc.? How do you start networking into the appropriate support? Even the privilege conversation would change dramatically, I would think, if you have to deal with European.
Yeah, and so the way we do it is we, as part of our team, we work with Kathleen Harris and some of our privacy folks in London. This actually was a UK German client, so in this particular example, and so there a decision was made based on advice of UK counsel and EU counsel that it was permissible under these facts not to disclose. But again, you do that before. You make these decisions before, or at least you have thought it through before. Like with war, the moment the war starts, all the plans go out the window. But at least you've thought it through, and you don't have to start thinking from scratch.
I'm intrigued by the last point. Ken, maybe you want to comment on that. How can civil litigation help you in the investigation?
Most of the time, civil litigation is we're on the right side of the V, right? The company is being sued for something. But sometimes in the early days of a breach or of an incident, you can use civil litigation as a tool to obtain information about what actually happened, who's involved, the breadth of the problem. You can even do it in ways that are fairly quiet. There are mechanisms under the Lanham Act and some other statutes that let you file essentially ex parte proceedings. Sometimes, I think Marcus has even done one that's a John Doe ex parte proceeding, where you can get into court and you can get court orders.
Company A versus John Doe's 1 through 10, and got expedited discovery.
So you can get expedited, very quiet. It's not easy. And not all courts will go for it.
What are you getting discovery of? I'm sorry.
For example, if you know that the breach went through one internet service provider, and you want to follow who paid, who paid for that internet service provider, you need to get a subpoena to go after that ISP.
And most data that we're talking about would be fall under the definition of a trade secret. And you could, if it's a competitor, an ex-employee, someone who started a new company, you can bring a trade secret claim against them and seek discovery to find out the extent to which they took your information. We've done that in multiple cases.
And intrusion itself is it's normally criminal under 18 U.S.C. 1030, but there's also civil liability under that, so you can file suit under intrusion.
So this is, I don't mean to take us down a very esoteric path here, but what's happening particularly for smaller companies, and maybe even public and non-public companies, is the use of service providers. For example, if you're a hedge fund or hedge fund of funds, you're using a fund administrator. Most of your clients, even though they're technically paying the fund administrator to be the investor servicer, are accessing account statements, K1s, things like that, through the fund administrator. But because they're an LP in our fund, they could hold us accountable for a breach of data, I think. And my question then is, at what point can you get in there and start working with a cloud provider or working with a fund administrator, some service provider? At what point can you cooperate with them or get information from them without turning it into a he said, she said game, and everybody goes to a very defensive posture and realizing that the situation could get very ugly with damages?
Well, it's the situation you describe is a complicated one. So let me start with a more simple version more simple version of that. So very often what happens is there has been a typical example would be a breach involving a credit card account information, such that the bad guys begin to disseminate private credit card information, and people begin charging things on consumers' credit card accounts. The banks, the credit card issuing banks, typically have a liability limitation policy. So the consumer is only going to be liable for either zero or very little, maybe $50, something like that, on that credit card. But then you've got this complicated problem that results, because you've got the company who's arguably responsible for maintaining the data and the breach that causes dissemination. Then you've got the banks who are dealing on the one hand with the consumers who are screaming at them, and on the other hand, they're holding the bag for the liability on the charges that have been made. Typically, what you would love as lawyers to have that all set out in advance by contract, and who's going to be responsible for what. More often than not, it is not, and so you really have to, in my experience, in those contexts, you really have to get the lawyers involved right away and create an atmosphere of cooperation. That this is about problem solving, not about finger pointing, and resolving it as quickly and as quietly as possible before there's any kind of massive litigation. In the context that you just described, I think the same thing pertains.
Well, I had a situation very similar to that, and Ken's advice was followed, where my client, who was the ultimate, let's say, financial institution, hedge fund, got in touch with them, said, get your counsel involved. We think there's been a problem. Let's work both lawyers together. We have cross-indemnity agreements already, and let's find out the extent of the problem working together in kind of a joint attorney-client investigation. And ultimately, in that particular case, it turned out to be less of a problem, and nobody ended up filing litigation against each other. But you each owe each other indemnities depending on who's the negligent party. So it pays to take it to a high level and try to work together.
Joint defense agreement.
Yeah.
When you're investigating the attack, in a lot of cases, it will happen at a vendor's site. So you have proper contracts, the right provisions, the GLB required language. You brought up cloud computing. That is a challenge for financial services. It's cheap, but they're not going to stand behind protecting the data, nor are they going to take on the obligations to make you whole if there's a breach. And the GLB, if you want to read it carefully, it requires companies that contract with third parties as necessary providers to make sure the data is protected, and there's enough teeth in your contract to stand behind the protection. Most cloud computing companies will not pay you anything beyond the simple fee you've paid them. So I don't think that's enough of a sanction if there's a breach. Most cloud computing companies like to move your data all over the world so they can keep your costs down. That's going to be a challenge for financial services. And I don't know of any financial services company as of today that's entered the new cloud. They've gone into private clouds, but those are ASPs, but not the type of the cloud that Salesforce will offer you, or someone that's not as protected. And as much as they'll tell you that great protection, they'll show you systems, since you can't control it. HIPAA is another problem in that space too. A lot of the healthcare providers are now becoming cloud-based, and there's a lot of information that HIPAA protects that you have to be careful about as a company, because it's your employees' medical information, etc. And if you're going to go into the cloud, there's challenges around that.
All right, let's assume now that you have determined that customer information of some sort has been invaded. Why don't you walk us through when it triggers victim notification? In other words, what type of data triggers victim notification, and what type of victim notification is required? I think this is a pretty difficult and complex issue, but Yusuf, maybe you want to start us, and then these guys can.
Well, there's different states have different requirements as to what the notification requirements are. The initial analysis we undergo is the NPI that's breached. So if it's a customer name or an address, in its alone, that's not NPI, but it's name, address, plus other factors like social security, driver's license, digital signatures. There's a whole list of other factors you worry about. Then, if you reach a conclusion there's a breach of NPI, then you have an obligation to notify the customer and the GLB as well. And what does notification entail? You'll discuss that with counsel, inside or outside, work out the type of communication. We'll have some samples in our disaster response plan as to what notification constitutes. And then you'll also have to notify the various attorney generals of the states. So California has a tough standard. We've defaulted that standard. If there's that breach, we'll do the notifications.
So we'll go through, in California, if it's a name and address, that's not enough.
No,
but if it's a name and address plus what would require victim notification?
Either social security number, driver's license number, account balance.
What about account number? If it was that and a Schwab account number, would that be?
Account number with a name may get you there, but account number alone not.
Right.
There's sort of a golden triangle in identity theft. It's name, date of birth, social security number.
That's the highest level.
That's the highest level.
Right.
And so that's they call it the golden triangle. If you have those three, then an identity theft worth his or her salt can steal your identity.
Right. But is there less than that requires victim notification?
It depends on the state. And in fact, we keep this little chart that we update periodically going through state by state. And some states have absolutely nothing at all. And so, I've had situations where I think it was North Carolina, we had a doctor's healthcare provider, and they lost a bunch of names and some other information. And there, the issue was, it was very nuanced. It was, if you determine that there was not a substantial risk of financial, personal, or reputational harm, then you don't need to disclose. We hired an expert who analyzed this. He was a former FBI guy who wrote a report saying, you don't have to disclose here. We put it in the file, so we didn't disclose. We've had a situation where there was really the crown jewels on a disk, but the disk was securely encrypted, and so in that particular state, encryption was a presumption that effectively it was no breach, and so we were fine under that state.
This area is just a mess. I mean, the fact that you have so many differing standards in different states as to what's the trigger for notification and sending out letters and such, it really creates a potential minefield because in a number of states, non-compliance with very strict disclosure laws can result in civil penalties and other enforcement mechanisms by the Attorney General, and you can really get yourself into trouble. And it's very difficult, particularly, it's one thing for a very, very large company, but for a smaller growing company to try to sort through and deal with who may have business in all 50 states, to deal with understanding the obligations in each of the states, especially when some of them are very nuanced. Typically, in some states, it'll be unclear whether you have to give notice or not, and you can do things like call. You can call the Attorney General's office and get informal kind of guidance or opinion that you can fairly well, rely on. But that's a burdensome thing to have to do in multiple states.
There is some good news. Believe it or not, it may actually come from Washington, in that there seems to be bipartisan support for federal legislation here that would preempt the state laws. The good news is that there will be a federal standard, and there is some exceptions. So, for example, HIPAA would not be preempted and stuff like that. Financial institutions would not be preempted. I won't go over it, but we wrote it up, and it's in your material here. There's an article that lays out the various statutes. Dianne Feinstein has one. And so the sense is that something like that will actually get through because of just the need. Both Republicans and Democrats think that it's a good idea.
Okay, and so what is high tech?
High tech is a version of, it's essentially expanding HIPAA to other areas, essentially groups that work with healthcare providers. But those are fairly clear, HIPAA and high tech, because if you fall into those, then you're federally regulated, and what you're required to do is fairly clear. Where it's dangerous is if you're you've got something and you have you're a retailer and you've got customers in all 50 states, and somebody steals your database of clients, like your company perhaps, and then what do you do in all of those 50 states? That's tough.
The common thing in each state is you have to give quick notice. You cannot sit on it once you've concluded notice is required.
Right.
So you tell the customer that there's been a data breach.
Yes.
And then do you leave it to the customer to decide what to do about it? Whether
We'll
to change passwords or cancel his credit cards?
Also call certain credit agencies or data protection agencies, and we'll pay for all of that.
And sometimes a lot of companies will offer identity theft,
right.
Resurrection type work.
And then if it's your company, you offer to pay the fees that the client incurs by talking to the data.
We've set up relationships with various credit agencies already. We'll give them a dedicated number. They'll go through a process and register their information as compromised, and they get 3 years of 5-year protection based on that.
And in that regard, by the way, in case you're wondering, so it is very common to when you give notice to offer credit monitoring as sort of the minimum, like a year to everyone, and the take rate, the number of people who actually take the company up on that is typically very, very low, extremely low. So the agencies and other vendors involved in this area you can negotiate a reasonable rate to get that kind of. I mean, it's still expensive, but a reasonable rate to get that kind of service. And I think 3% would be a reasonably.
Yeah.
Keep in mind there are consequences for you if you don't follow these various statutes, including if you willfully, for example, under the proposed federal legislation, if you willfully decide not to disclose and you're wrong, you could be criminally liable. So, and some of the states go that way too. So you actually can't not do anything. I mean, you can't not do something.
So we touched on this a little bit, but sure, go.
I heard, isn't the strictest state right now Massachusetts when it comes to?
I think that's right. Yeah, but some states, like I think it was Nevada or Utah or one of the states, has nothing at all. Is it Nevada? Yeah, has nothing at all. So it's really bizarre because if you're a company like most companies where you're sending goods all over the country, you oftentimes don't know what to do.
I just know because we deal with a lot of banks and the company, and they put Bramley, Wiley, and Massachusetts.
That's interesting, yeah.
Yeah, we put in a plan basically to cover Europe and Massachusetts, and we figured if you cover Massachusetts, you actually, you do whatever you're going to do in Massachusetts everywhere. I mean, you might be overdoing it, but
It's one of the rare instances in which California isn't leading the world, right? Yeah. So we touched on this briefly, but I want to cover both the benefits and the downsides of cooperating with law enforcement.
And I'll touch on it very quickly. Look, the major benefit is that the law enforcement just has much more power than you have, and so if you can investigate what is within your turf, but if people are really attacking you, they have agents and with guns and search warrants and grand jury subpoenas, and so that can be useful for you. It also, look, if you're working cooperatively with the government, you're likely to be viewed as a victim, and so they'll treat you nicely, and you may, well, depending on certain circumstances, end up getting restitution, which is damages, depending on the particular facts. I've gotten damages in some of these sorts of cases.
Let me just ask, there's prosecutorial discretion.
Yes.
And not all issues are of interest to the government. I've been in cases in which there have been trade secret issues, and we've gone to the government and they said, it's a civil issue. We're not prepared to do it. From your prosecutorial experience, what are the criteria that would make it likely that the government would investigate a breach?
Light at the end of the rainbow, or light at the end of the tunnel. And really two things. One is they're afraid of embarrassment. And so if there are 50,000 victims, little old ladies, then they will investigate. They'll take it because they're charged with helping out the public. So they're very interested in that. And then they're looking for bodies. They're looking to arrest people. And so if it's something where the data is encrypted and everything's gone over to China and there's no hope of them actually ever arresting somebody, they won't be terribly excited about it. But if it looks like, the ring of identity thieves is hanging out in Detroit and they're able to figure out a path to get there, they're going to be all over that.
Well, let me ask you, you raised the offshore issue. So my client is an American company. We've done the internal investigation, and we believe that the hackers who stole our designs for our new product are in China. Does the government have tools?
Yes, it does have tools. China's hard. It's moving in that direction. But let me answer it slightly differently. When I was chief of the Major Crimes Group, we really focused on Eastern Europe, and I sent my guys over to Eastern Europe to just go to dinner and meet these people and have conferences. And now, if you start reading the press releases coming out of New York, they're getting bodies out of Latvia, they're getting bodies out of Romania because of the ground that was plowed 5-10 years ago.
And when you say going to conferences, you mean interfacing with
law
enforcement in those countries?
So they build up the relationships. And the U.S. is focused very much on doing that throughout the world. China's behind because it just takes a while to get through there. Okay. But that'll happen.
And how about some of the downsides?
So the downsides are look, you lose control of the litigation. The government may tell you, they won't tell you to do something, but they'll tell you not to do things. So, I was on a panel in New York where the FBI agents were saying, bring it to us right away. And one of the things we don't want you to do is take it offline. And it's like, but my crown jewels are online. And they said, well, if it's online, then we can do investigative techniques, undercover stuff. And it's like, yeah, but I'm going to lose my company. So there's a lot of tension, and you lose control of things, and you can't control the timing. It's also it's an on-off switch. You can't actually pull it back once you've gone to the government.
And I guess there's...
Yeah, and I call this the Oscar Wilde problem. As you know, Oscar Wilde went to the government and complained about a defamation allegation against him, and it turned out that the allegations were true, and so what he was talking about was criminal in London at the time, and so he ended up in jail because of it. So be careful before you go into the government, because you want to know that you yourself don't have criminal liability, and that works with the corporate criminal liability as well.
One thing I would add, just as an aside, is that particularly if you ever get involved in the defense space, government contracting, defense space in particular, sometimes you can reach out to law enforcement in the form of like the Secret Service, and they'll get involved and supplement. They'll do their own investigation, and if you can get the Secret Service involved, and if you have good internal security people who have good relationships with the agency, to get the Secret Service to do an investigation cooperatively with you can be a very effective mechanism, because they are not interested in prosecuting you. That's just not their That's not their bailiwick. But they will, if the Defense Department's involved at all, they will sometimes get involved, and their investigation can be much more rigorous and fulsome.
So their jurisdiction extends to where there's government contracts? Is that what
generally cybercrime in the financial area, because they used to be part of Treasury, they have jurisdiction there. So in the cyber area outside of the government contracts area, the big federal agencies are the FBI and the Secret Service, and so they have overlapping jurisdiction. And both those agencies have been very, very vocal about, we want to work with corporations cooperatively. It runs into competition, obviously, with the FCPA bar, where the government actually is very antagonistic to companies. So but you can, a lot of it is knowing the right people and talking to the right people, going to the right agent. I mean, one of the advantages of going to the government first is that you get to choose who you're going to. You get to choose the jurisdiction. You get to choose the agent who you're going to, who will work with you cooperatively.
Yeah, and by the way, we found that in all areas, and particularly in securities litigation. If you're disclosing, you get to pick, do I want to go to FINRA? Do I want to go to the SEC? Do I want to go to the U.S. Attorney's Office? And you sit around and figure out where you think you're going to get the best service and the least exposure. And that's a good choice to make with outside counsel in terms of their experience. So let's take a step back and talk about preventative mechanisms and how to prevent something to happen. And Yusuf, maybe you want to start off with how Schwab and other financial institutions choose to set up their data and their information so as to prevent an attack or to limit it.
Yeah, it's back to the integrity of your security system. Everyone uses standard firewall technology. We have the rule that if you're 500 miles away, we'll send you an extra thing to give us a different password supplement. We'll give you tokens if you tend to do a lot of trading or banking activities in cafes or travel a lot. Then we have group internal. There's the ISS group that monitors systems on a daily basis, and then once there's a breach, the risk management folks kick in, they take it over. But the technology itself is pretty much what everyone else uses, because you want to be in the same company with the rest of the world in this standard technology, so that you don't get there's no lawsuit saying you use something that's inferior to some other company's technology.
In terms of assessing risk, and in other words, everything you do, you assume the bad guys are just one step behind you. Do you use outside experts to come in and take a look at your systems and let you know if you're up to date?
We've contracted with different entities that will come in and do audits and tell us whether they feel it's adequate or not. People will come and present new trends, new technology all the time. So our technology folks are always in the forefront and talking to them and making certain that we have the right technology in place. But we'll have forensics folks come in and look at our systems.
Because I would think that no matter how good you are this week, next week it might not be good enough, and you need somebody to help you keep up with the trends.
Right, but judging from the existing history of losses, we're doing well. So we keep up with the trends, and the malware gets updated, the firewalls are what they are. There's always password issues. We'll recommend people change their password every 6 months. We'll send you an email alert notifying you to change it, and a letter and a word and a number to it.
And presumably the data is segmented so that depending on where you are in the organization, you have only limited access, right? So
it's controlled access.
Right. Somebody in the branch in San Francisco can't look at the customers of the Hong Kong branch or of another branch.
You'll have to get through many systems to get to that point, and it's all logged, and
Right.
you'll be able to see it. In the end, the data all resides on the main server. So if someone in one branch wants to get into your account and look at your social security number, they probably can. But there's going to be a log. Why did they get into that account?
So they'll know where the look
absolutely.
at came from.
Yeah.
But to your point, Gil, I think, the concept of a security audit in advance is by an outside vendor, or even if it's internal, but particularly if it's by a reputable outside vendor, is a very good idea for multiple reasons, right? First of all, it may actually expose some issues that you want to remedy, which would be a good thing to do in advance. But two, and I tend to look at these things from the class actions that follow, it is a great thing to do when you're being accused of acting in a negligent fashion, to be able to say, well, we engaged this company to do a security audit. They identified these three things. We fixed those three things. And if this breach or this incident still happened, yes, it may have happened, but you can't.
It's not negligence on our part, right?
And one
it's
thing,
like SAS 70s. You'll have internal SAS 70s, right? So it challenges your protocols and it gives you your results on the challenge, because all of that gets reported to the audit committee that sits on the board. So you want to make sure the board's insulated.
So the audit the audit committee will review not just financial statement reporting, but also security of data.
Right. You have your internal audit folks. They're going to run repeated audit checks to make certain systems are working as we say. They'll have it verified by external forensics. The audit committee will get a report saying, here are the shortcomings we noted, and here are the remedial actions we put in place. And since you're reporting to the audit committee and the board, ultimately, it's the seriousness of the process that kicks in.
Yeah.
and one thing you have to be very careful with is, a lot of times the IT guys are kind of like woolly guys with long hair who say, this is my turf, I've got a silo, stay out, and we're all very comfortable letting them handle it because the ship runs well. That's a big red flag because oftentimes they're pack rats, and they've got all of this extra data there that you should have gotten rid of a long time ago. And if somebody gets into the system and gets that stuff and it gets out into the internet, you're in a lot of trouble. So one of the, you need internal auditors to actually get in and do that stuff. I had a retail client where they had a very big name brand company, had a IT group that was essentially, they were the gurus and nobody touched them, and it was a big problem.
Why don't you go to the next slide, Gil, because I think
This is
some
good.
materials too. We don't have to dwell on this, but just the FTC has put out guidance on best practices in the context of personal consumer information. And I won't, given the time, I won't walk through it in detail, but it basically suggests that you conduct an audit of the nature that we're describing here, and you're taking stock of what information you have, scale down. Do you really need to be retaining all this private consumer information? If you don't need it, don't collect it, or don't retain it. Make sure you've got adequate controls to lock the information down, encrypt it if appropriate, which it almost always is. Dispose of what you don't need, and plan ahead to have an incident response.
Yeah, I think the number 5, the create a plan, is particularly important. It's like, disaster preparedness. Everybody has or most companies have a plan. What happens if there's an earthquake and we can't talk to our employees or get into our office? But you, for example, you have a data incident response plan at Schwab as to what, it's kind of a checklist for whoever is sitting in the hot seat as to what to do if one of these things happen. And it allows you to do clear thinking before stress of the actual event.
And item 6, which is not on this list, but I would add an item 6, which is to think about in advance insurance coverage. Carriers are now much more comfortable providing different kinds of coverage in the context of data, cyber security, and data breaches. And the one thing, of course, you don't want to have is a business terminating incident. And so having coverage that will allow you to survive even if the worst happens is really not a bad idea at all. And a number of our clients have had coverage, and they have high deductibles, so you may still make an expensive proposition, but it won't be business
Is there a particular word for that type of coverage or particular acronym for it?
Data incident.
Some kind of criminal.
Yeah.
I think it's a criminal coverage, isn't it?
But we have. I mean, I've seen cybercrime coverage. I don't know what it's
Cybercrime.
called.
Cybercrime.
Yeah, cybercrime data security coverage. I've seen, there's one acronym that's that I'm aware of that's hit out there, but there are common policies that are available.
Well, the last part that we want to talk about is kind of maybe not the worst case scenario, but the scenario that you're trying to avoid is one of these events leading to interminable civil litigation. And Ken handles these type of cases, has one multi-district case right now. So why don't you walk us just through a little bit what happens and what kind of cases people should be aware of?
Sure. Well, I'm mindful of the time, so we have about 5 minutes until 10. We said 10. We have a few more minutes if I try to be brief.
I have a hard stop.
Okay.
Yeah,
Well,
I'll duck out too. That's fine.
Okay, I'll talk fast then, because this stuff can be very scary as well. So right from the outset, you need to assume that if there's been an incident, particularly a breach of consumer data, that there's going to be civil litigation that can easily follow. As I mentioned, there is a fairly well-developed and increasingly more well-developed plaintiffs' bar out there who are scanning the wires looking for potential classes to represent. Although there's an occasional individual action where some particular person, if there's a very high net worth person who has a lot of money that is lost in the context of one breach, they might bring a lawsuit. But principally what we see are class actions that are filed when there's an incident, not unlike the one that Marcus described here, with 5 million consumers potentially affected. Even if the damages with regard to each one are very, very small, 5 million times anything adds up to a big number pretty quickly. So we mostly see class actions mostly filed in federal court. Under the Class Action Fairness Act, CAFA, most class actions in state court are ultimately going to be removable anyway to federal court. So even if the claims are based on particular state laws, these cases tend to end up in federal court. They may be where you're located, in the federal court where you're located. They may be where many of the potentially impacted individuals are located, or it may just be in the district where the plaintiff's lawyer lives and feels comfortable with the courts and just finds a plaintiff who can represent the class. So you may find yourself litigating a class action about a data breach involving your company in far-flung places that you never thought you'd have to litigate before. And unfortunately, that's as common as being in your home district. Really, anybody's at risk for being sued, but the consumer-facing companies are the ones that are most likely to be sued because that's where the plaintiff's bar is most comfortable litigating. So whether it's in health insurance, financial institutions, telecom, those are the kinds of businesses that really seem to get hit with these lawsuits the most. Retail is huge, unfortunately.
I mentioned in the beginning about the telephone recording where there's a $5,000 minimum payment for each, theoretically. Are there similar statutes or state laws where you face a certain minimum number?
There are different laws in different states. California is unfortunately not one of the most friendly states in this context. So on this point, the claims you may face can be, there are some federal statutory claims, many more state statutory claims. Typically what you see are negligence. That's the core of most of these claims. But there are some state statutory claims that are very, very troublesome. California, just as one example, there's something called the CMIA, the California Medical Information Act. And that has a provision that provides for, in the context of a disclosure of private health information, a penalty, a statutory penalty of $1,000 per disclosure, with or without a showing of any actual harm. So you may not have had any injury whatsoever, suffered any monetary or other cognizable harm, but the company could still be on the hook for $1,000.
Per customer.
Per customer.
Right. So you see 1,000 customers, you got $1 million exposure. If it's 10,000, this is very, very difficult and
very serious,
scary litigation.
There's a lot of litigation about these kinds of statutes. There's a lot of dispute about whether, for example, under Article 3 of the U.S. Constitution, you have standing. There's actual case or controversy. If there's no injury in fact, to thereafter be able to get a statutory penalty. The law is very mixed. The Ninth Circuit law is not that great. The law in other circuits is good. The Supreme Court, on the last day, a little known fact is on the last day of the term, the court not only issued its decision in the Affordable Care Act, but it denied cert in a case that addresses this very issue. So it left the question unsettled going forward. As a result, it poses a very serious risk for settlement because you may be exposed to if you're in the health industry, you may be exposed to an awful lot of exposure.
So take your pick if there's particular points that you want to cover in closing.
Just go back for 1 second, and I'll be really quick about this. Just you probably all know the litigation process, but typically the way class action litigation proceeds in this area is there will be multiple class actions filed within a week or two in various districts across the country. One or more of the plaintiff's lawyers will seek you out and begin to jockey for an early settlement and to promise you that they can get you a cheap early settlement and resolve all the cases. Sometimes that's true. Sometimes that works. But more often than not, it doesn't. And then you have to go through a process of deciding whether you're going to litigate multiple cases at once or try to have them consolidated in one court through the multi-district litigation process, which is usually what happens. And then you proceed with the normal litigation, motions to dismiss. A big point of contention tends to be class certification. Very often you can get class certification denied in these cases. Given the time, I won't go into the details. But there are various points in time in the litigation when you can knock out or limit the class significantly. What you don't want to do is get to trial. No data breach cases have gone to trial that I'm aware of any significance ever, largely because either they're proven to be meritless by the end, or there's enough merit that the company just decides to settle. And virtually all cases end in a settlement, and depending on how well the facts have played out, they can be good settlements.
I've had to testify as an expert witness, but it's settled right beforehand.
Yeah.
And I would just say, probably all of you are aware of this, but I mean, just in a settling class action, just the cost of class notice, individual notice, is very expensive for companies, and so that it's what may seem cheap may not be cheap because you have to give class notice and you don't get res judicata effect on the whole class unless adequate notice has been provided, and that's a subject of great negotiation as part of these settlements.
Maybe talking about the last slide, the litigation counseling slide, would be just to wrap it up.
Yeah. Yeah, I guess this is a nice way to wrap things up. So, just like all the precautionary things that Yusuf talked about, for litigation, like we said, you should really assume litigation at the outset and keep that in mind in everything you do. So you'll be thinking about, should we issue press releases, should we make disclosures, should we talk to the government, the securities disclosures, what kinds of steps should we make in terms of remediation, should we hire counsel, all those are the right questions, but they should all be answered through the lens of one day I may be sued. And I want to make sure that the record that I have going into litigation is going to put us in the best posture for a good outcome.
Okay. Well, thank you. Thank you, everybody, for coming. We're here. We're not going to leave. If you have some questions, we're happy to continue a discussion. It's totally up to each of you. Thank you very much for joining us today.
Thank you.
Yeah, thanks for coming. Well, I guess we'll get started. Welcome. Thank you all for coming to Arnold & Porter this morning. My name is Gil Sirota, and I'm a partner in the San Francisco office. I do litigation, and I came via the merger with Howard Rice as of January 1st. Our bios are in the little booklet, so I'm not going to go into it in great detail. This is Marcus Asner. He's a partner in our white-collar crime group. He was a former assistant U.S. attorney in the Southern District of New York, and he works in our New York office. Yusuf Kasim is from Charles Schwab and Company, one of our dearest and most enduring client relationships, and he is the head of their legal intellectual property group and does a lot of work in the area of privacy and data breach and so on. And Ken Chernoff is a partner in our DC office, formerly with the Justice Department in Washington. He is the head of our business litigation group worldwide. And Marcus and Ken are the founders of our data breach response team. And they put together a group of folks who are trained and ready, willing, and able and employed doing exactly what we're going to be talking about today, which is helping clients with internal investigations and litigation and regulatory matters arising out of data breach situations. So I thought, rather than mentioning what Eric Holder said, which is important, yesterday there was, let me say one other thing for California law purposes. This is being recorded, okay? Also, you should feel free to interrupt us with questions and have a dialogue as we go along. We want to have this informal and meet your needs in terms of responding to what your concerns are. But we are taping this. It'll be posted on our website, and a couple of clients who couldn't be here today wanted to listen to the presentation. Yesterday, there was a press release by Joe Lieberman, the senator from Connecticut, about the need for further cybersecurity legislation. And I found a couple things interesting. The head of the National Securities Agency and the commander of the U.S. Cyber Command said that the theft of industrial information and intellectual property is the greatest transfer of wealth in history. Companies lose $250 billion per year through intellectual property theft, and another 100.
But this lack of publicity showing how much money we're not losing right now, so we are keeping up with them, and there is this little balance that's in play. But unfortunately, it's one failure that causes all the problems for us. If there's a massive failure, we face publicity issues, we face damage to business reputation. We have a statement out on our website guaranteeing you that we'll stand behind our security and your money. That's all expensive for us if there's problems. Then you have the regulatory agencies managing us. Since GLB, Graham-Leach Bliley, we need to be careful about how the NPI is protected. If we contract with third parties, how we protect your NPI, the requirements we put in place in agreements, the indemnifications we seek from various vendors. And then there's always a threat of both criminal and civil litigation against companies that fail to protect the data. But again, it's the reputational harm that we're worried about. And we have an elaborate process in place. We'll get into the decks later when there is a breach, what we go through, how we protect it, how fast we respond to the individuals, what measures we make available, and how we protect your data. From a financial services company, a very busy brokerage company, we've been lucky. We haven't had a lot of exposure to breaches, simply because I think we have a very good technical staff, we have a very good ISS group, and good forensic folks working our back-end systems to ensure that your data is kept protected and private.
Let me ask you a couple of questions. There have been a couple of major items over the years where online trading systems, not just Schwab's, but others, have suddenly gone down and customers couldn't transact. Have in the industry, has that ever been traced to kind of cyber crime as opposed to just a technological issue?
It's mainly technology or servers going down, or you had the problem in New York where the power circuits went down, the exchanges couldn't work. We had issues where the systems did slow down because of volumes. A lot of trading volume comes in. You have massive servers in place. Lots of MIPS are being used, but at some point you need to switch machines on to take the volume, and you try to load balance. Times when we've gone down is when the load balancing didn't work out, the systems didn't communicate well, and then suddenly things slow down and trading is halted. Or if there's over trading in a stock, we'll just halt it from the exchange perspective because we've been told to start slowing it down. But no cyber trade, to my knowledge, cyber hacking has brought any systems down from that perspective. You had the big problem with ChoicePoint and their breach around sensitive data, but that was more their systems and some stuff on their end that caused it. That was all the publicity on that topic.
Thanks. Ken?
I'm just going to say I'm glad to be here. Thanks for showing up. And it's a very fascinating topic. I get involved in the civil litigation, so I get involved hopefully at the front end when there's been a data breach or a hacking or something that's presents some exposure for a company. But more often than not, when I get involved is when the threat of litigation has emerged or an actual lawsuit or set of lawsuits has been filed. And I'm really glad that Yusuf is on our panel today because I'm amazed that he and Schwab have been able to avoid any significant litigation. It's actually a remarkable feat in this day and age in this area of the law because, as Gil was kind of recounting how data breach privacy issues are becoming more and more commonplace and sort of common in the public press and the news. Everyone's kind of talking about concerns about privacy. People are much more attuned and concerned about their personal data being compromised. And as a result, with the advent of some new laws that I'm sure you've been dealing with and we'll talk about, there has grown a new plaintiff's bar, which is much like the securities plaintiff's class action bar that emerged in principally in the 80s, is growing similarly in the data breach security area. And these folks, prowl the public press for disclosures regarding data breaches and similar events. And more often than, frequently now, they are filing lawsuits, where you file first and ask questions later. And even those lawsuits, whether they are meritless or not, pose a lot of reputational risk, like you were describing, Yusuf, and potential exposure to a company. So
we're also seeing the state AGs coming in more and more and filing suit, and also the FTC, of course, is a big regulator in this area.
Yeah, the FTC fined Google yesterday, 22.5 million, I think, around the way they circumvented the privacy protections in Safari. There seems to be a battle between Google and Apple around Safari and how the privacy controls work in the technology. But the FTC also has a requirement on companies like Google and Facebook to annually provide an audit plan about how they intend to protect your private information as opposed to
$14 billion due to cybercrime, a number that rises to $338 billion when the costs of downtime due to crime are taken into account. And I think you've probably seen a couple of press reports about a survey that was done of mid-sized companies where fully 50% of the companies in the survey reported that they had been victimized during the last 12 months by some form of data theft or hacking. So this is a real serious problem that's very likely to hit everybody in this room, law firms included. I thought Marcus could take us through just really briefly from his perspective as both a prosecutor and as a civil litigator, the types of data breaches that we are seeing and where they're arising.
So welcome everybody to Arnold and Porter. Our hope is that this is going to be a small, intimate crowd where people can add things and discuss. In my past life, when I was in New York as a federal prosecutor, I was chief of the cybercrime group and handling a lot of the data breaches from the government side. And now that I've been at Arnold & Porter for the last 3 years, I've been handling it from the civil side, so I have a little bit of a different perspective. It's a little bit odd for me to be in Silicon Valley and tell you about cyber threats because obviously this is the epicenter of a lot of this stuff. But let me go through it briefly, at least from my perspective as an attorney. Data breaches are the things that are very much in the news these days. To me, the astonishing thing is just the trend. In 2004, when I was a prosecutor, I issued a press release because I had just taken down the biggest identity theft in U.S. history, and it was just astonishing. It was the front page of the New York Post, and that was 30,000 credit reports, and that was the biggest ever. And now, many years later, I'm dealing routinely with millions of identities stolen, and it's just gone up. And so the trend has gotten to be that these things are bigger and bigger. And a lot of that is just because of the use of more and more data on computer systems. Now, not all data breaches are the same. The Cummings data breach, the one with 30,000, was 30,000 credit reports. So there was a lot of information. And one of the things that we're seeing is there may be larger data breaches in the sense of volume, but the information may not as useful for some of the bad guys. But there's other threats out there for you and your companies. Obviously, there's hacking. You're all very familiar with it. Anywhere from some 17-year-old kid who's hacking into some the DoD website because he thinks it's fun, to actually people going out there and trying to get data for the purposes of doing bad things, to destroying your data and stealing your trade secrets. Botnets are a big thing in the cyber world, where a huge proportion of the PCs in America are actually controlled by other PCs, and they serve as slaves. They're called bots for robot, and they're nets. And so the bad guys will use these, and one of the things they'll use them for is a dedicated denial of service attack. The easiest example of that is they'll send 1 million emails to the same email server and try and crash your system. And it turns out that these various cyber attacks are, people think they're immune from them, but I thought it was very telling. In December of this year, I got a call because one of our clients was somehow wrapped up in the mega upload case. And so I was watching that throughout the day, and mega upload, some people were arrested by the Department of Justice. And then later that day, the Department of Justice website crashed because the Anonymous did a denial of service attack on them. One area we're seeing a lot of these days is corporate espionage. It's a huge part of everything. And then, of course, also that's foreign espionage. That's a big focus of the Department of Justice these days, but also of our clients.
All right, and let's just turn to how this impacts companies. And Yusuf and Ken, you might want to have some comments on this. Obviously, bad publicity is at the top of the list, and damage to companies' relationships. But
yes, I think Gil started the presentation talking about the impact of how much money is lost in the cyber threat space. We've been successful in as much as the folks hacking into our systems are becoming more sophisticated. So are we, managing the hacking, watching the systems, watching trends. For example, we'll continuously monitor your IP address when you log into your accounts, so we can see consistency. If we note that you're more than 500 miles away from home, we'll send you a robotic ping to add an additional password, or ask you for different passwords, so that we certainly still you checking into your account, etc. If you're one of the customers that likes to use a cyber cafe all the time to access your accounts, we'll send you a token, which is a further authentication mechanism. So we try to keep up with the sophistication of the hackers, and I think there's a lot of publicity about how great the hacking folks are.